Hello friends, welcome to Law and GK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. And friends, in today's video, we are going to discuss the recently held Delhi Higher Judiciary exam paper of 2023. देखिए एग्जाम पेपर आया कुछ इस तरीके से. This exam was held on 20th August 2023. And these are instructions. 2 hours, 150 questions. Blue and black ballpoint pen can be used. And there is negative marking of 25%. I hope कि ये videos आपके लिए बड़ी useful रहेंगी. So friends, if you are preparing for judicial services, this channel will be very useful for you. आपके लिए बड़ा ही beneficial रहेगा. And अगर आपको ये वीडियो अच्छी लगी हो तो जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ. And don't forget to subscribe the channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. And अगर आपको हमारे efforts अच्छे लगे हो तो in addition to like and subscribe, kindly give us a super thanks. Super thanks is a way to appreciate the content creator. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए आप जितना भी अमाउंट चाहें डोनेट कर सकते हैं. मिनिमम इज 40 रुपीज. सो डोंट फॉरगेट टू गिव अस अ सुपर थैंक्स. सो लेट्स मूव टू द क्वेश्चन पेपर. So question number 1 starts with English. The phrase cheek by jowl means very close together. बोलते हैं ना भाई अपने चीक से चीक मिला के रहते हैं फ्रेंड्स, है ना. तो very close together. 2 is the answer. Next is 2. The blanks in the sentence below can be filled in the correct order as you need to dash more judgments to prove your point. So what it is? Cite. You need to cite means आपको रेफर करना पड़ेगा. Cite का मतलब क्या? रेफर. More judgments. The factory site needs to be examined carefully. Site means जगह, the place. फिर the mangled car was a horrible sight. SIGST. It means scene of occurrence. दृश्य बोलते हैं दृश्य. So क्या बन जाएगा ये? 4 is the answer. This is 3. Which of the following is spelled incorrectly? Receive, this is correct. Receipt is correct. Achieve is wrong. It is IEVE. And perceive, it is correct. So 3 is the answer. Next is for the sentence. Neither Ravi nor John have done their work. Can be corrected as neither Ravi nor John has done his work. Not there. This one is same and not have. So 1 is the answer. Next is 5. Which one is not correct? A director would not be liable simply because they are holding that position. A managing director can be made liable because of their position. Even if the complaint is quashed against the company, the complaint will be maintainable against the directors. This is not correct. The vicarious liability upon director is legal fiction created by section 141 of the Companies Act. What is not correct? 3 is not correct. 3 is the answer. Next 6. A check is issued by W to discharge the legal liability of her husband H. The check was drawn by her on her own account. The check was written on presentment for insufficiency of funds. The payee can file the complaint against W as she was the drawer of the check. जिसका चेक है उसी को लाइबल करेंगे obviously. 2 is the answer. Next is 7. Where any borrower makes default in repayment of secured debt or any installment thereof, the account is classified as non-performing asset under section 13 of SARFAESI. Then secured creditor may require the borrower to discharge the liability within 60 days from the notice given under section 13 subsection 2. So 2 is the answer. Next is 8. When is the borrower said to be in default with respect to debt securities under the SARFAESI Act? Non-payment of debts after notice of 90 days. 1 is the answer. Where is the definition of default? In section 2J of SARFAESI Act. Okay. Next is 9. In case of disobedience of any injunction order made under Order 39, Rule 1 and 2, The code under Order 39 Rule 2A may order attachment of property of person guilty of disobedience, yes. Order detention of person guilty of disobedience in civil prison, yes, and for maximum 3 months. So it is both 1 and 2, 3 is the answer. Next is 10. A secured creditor may initiate recovery proceedings under the Recovery of Debt and Bankruptcy Act 1993. So they are asking the question from IBC, Insolvency and Bankruptcy Code, and the moratorium is mentioned in section 14, and over there it is mentioned that where it is applicable and it is not applicable. So against corporate debtor who is under moratorium, so debtor who is under moratorium, no suit can be filed, so it is incorrect. And the security interest of corporate debtor is under liquidation process, even at that time it cannot be filed. When against the guarantor of the corporate debtor during moratorium period against the corporate debtor. So this can be done how? Subsection 3 of section 14 mentions that where the moratorium is not applicable, and its clause B mentions about surety or guarantor of corporate debtor. So this is correct. 3 is the answer. Next is 11. The secured creditor makes an application in writing to the Chief Metropolitan Magistrate (CMM) or District Magistrate for taking possession or control of the secured asset under section 14 Sarfazi Act. So CMM or DM shall pass suitable order for the purpose of taking possession of the secured asset within a period of 30 days from date of application, which for the reason to be recorded may extend up to the maximum 60 days. It is correct. And it is mentioned in section 14 Proviso 2. Alright. There is no time limit for passing the order. No, it is wrong. 30 days granted date of application, not extendable. Wrong. So 1 is the answer. Next is 12. Which of the following is not mentioned in the list of notifiable diseases under the Schedule 3 of Factories Act? Pneumonia is not there, so 2 is the answer. So there are basically 3 schedules in Factories Act, 1, 2, 3. Third schedule talks about the notifiable diseases, and toxic anemia is in entry 16, anthrax is entry 11, asbestosis is entry 20. Schedule 2 talks about the permissible level of chemical substances in work environment, and schedule 1 is of list of hazardous industries. 2 is the answer. Next 13. What is the minimum number of workers required in a factory for the appointment of safety officers as per section 40B of Factories Act 1948? 1000 or more. So 4 is the answer. Next is 14. Which section of the Payment of Gratuity Act deals with determination of amount of gratuity? It is section 7. 4 is the answer. Section 4 talks about payment of gratuity. 5 talks about power to exempt, and 6 talk about nomination. Next 15. Under section 7A1 of Payment of Gratuity Act, the appropriate government can appoint how many inspectors for the purpose of this act? 1, 4, 3, as many as it is fit. 4 is the answer. It is mentioned in over there as well. It is mentioned in there itself. Next 16. Payment of undisbursed wages in case of death of an employed person is envisaged under which section of Payment of Wages Act? It is section 25A. 2 is the answer. These questions has been asked from AIBE, All India Bar Examination. I have seen these questions over there. Next 17. Which section of Employees Compensation Act deals with special provision relating to captains and other members of crew or aircraft? It is 15A. 2 is the answer. Next 18. Within how many days of the service of notice by the commissioner, an employer is required to submit a statement giving the circumstances attending the death of the employee? In 30 days. 2 is the answer. And it is mentioned in section 10A of Employee Compensation Act. But it is nowhere mentioned which act they are talking about. But if somebody has studied this act, then only you can understand this question. Otherwise, it is very difficult. This question can be challenged. Next 19. Mr. X holds himself out to be the owner of residential apartment and leases the said residential apartment to Y for a monthly rent of rupees 20,000. In the suit for eviction and recovery of arrears of rent filed by Mr. X against Mr. Y, a defense is set up in the written statement that Mr. X is not the owner and it is in fact his wife, Mrs. X, who is the registered owner of the residential premises. Mr. Y produces a certified copy of the sale deed evidencing the ownership of Mrs. X. Civil suit filed by Mr. X is not maintainable as he is not the owner, or it is maintainable. Second is not maintainable. It is maintainable. How? The relatives of landlord is also comes under the definition of landlord. As Mr. Y has not disputed that premises let out by him by Mr. X and Mr. Y is stopped from disputing the title of Mr. X. 3 is the answer. Next 20. In execution of decree for recovery of money, immovable property of a judgment debtor was attached, auctioned and sold. Objections were filed by a person who had purchased the property from the judgment debtor prior to the institution of the suit in which decree was passed and who was in possession of the property. The court finds that auction was held on 18/10/2011, but auction purchaser deposited 25% of bid amount on 3/11/2011 and balance 75% of the bid amount was deposited by the auction purchaser on 4/11/2011. The objection will be allowed or not? It will be allowed and the auction and the sale set aside for the reason of delay on the part of auction purchaser. So there is delay. Auction was held on 18/10. And within what time period the auction purchaser has to deposit the 25% amount? Immediately, and rest within 15 days. It is mentioned here. Order 21, Rule 84 and Rule 85. So there is delay. It can be set aside. The property has already been auctioned, sold. Objection will be dismissed. No. Sold. Executing court will proceed to put the auction purchaser in possession. No. Will decide it on merit. No. 1 is the answer. Next 21. An application for correction of decree passed by the Court of Additional District Judge, Delhi, appeal where against has been dismissed on merit by the High Court of Delhi can be filed before the High Court of Delhi. 2 is the answer. Because they are talking about the appeal and the decree for correction and application for correction of decree passed by additional district judge. So this option cannot be and cannot go directly to Supreme Court. So only option here is 2. Next 22. Which article of the Constitution of India mandates that states shall endeavour to protect and improve the environment and to safeguard the forest and wildlife of the country? It is Article 48A. 3 is the answer. DPSP. 47 is duty of state to raise level of nutrition and standards of living to improve public health. Okay, 48 is organization of agriculture and animal husbandry. 49 is protection of monuments. Next 23. Which article of the Constitution of India mandates courts not to inquire into proceeding of the Parliament? It is Article 122. 2 is the answer. Next 24. Which judge gave a dissenting judgment in the matter of Vivek Narayan Sharma versus and others versus Union of India, popularly known as demonetization case? It was Justice B.V. Nagaratna. 4 is the answer. Next 25. The matter of A.K. Gopalan versus State of Madras with Union of India as intervener reported as AIR 1950 was decided by a bench of Supreme Court comprising 6 judges. 3 is the answer. Next 26. How many fundamental duties are enumerated in Article 51A of the Constitution of India? 11. 3 is the answer. Article 51A was inserted by 42nd Amendment Act. Alright. Earlier there was only 10 duties initially inserted by the 42nd Amendment. The 11th duty, that is 51AK, was inserted by 86th Amendment in 2010. Okay. Next 27. Which constitutional amendment provided for economically weaker section reservation? It is 103rd Amendment. 2 is the answer. Next 28. The 5 judges judgment of Honorable Supreme Court of India in the matter of Common Cause versus Union of India reported as 2018 is with regard to euthanasia. 1 is the answer. Next 29. The inquiry or trial pertaining to an offence under section 376, 376A, B, AB, C, D, DA, DB. The inquiry or trial shall be completed within a period of 2 months from date of filing of charge sheet. 1 is the answer, and this is provided in section 309 proviso in CRPC. At present I am doing Jharkhand Judicial Services series, so I have seen this question over there as well. Next 30. Which of the following judgment held that failure of issuance of notice under section 41A CRPC is an essential ground in favor of the accused to become eligible for bail? That is Satinder Kumar Antil versus CBI. 3 is the answer. Next 31. Default bail is sought under which section of CRPC? Under 167 subsection 2. 2 is the answer. Next 32. Warrant case has been defined under section 2X. 1 is the answer. 2W is summons case. This is no section. 2Y is words and expressions, same as in IPC. Next 33. Section 303 IPC was struck down by Honorable Supreme Court in case of Mithu Singh versus State of Punjab. 3 is the answer. This is very common question. Next 34. Which of the following provision criminalizes disclosure of identity of a rape victim? It is 228A. 3 is the answer. 228A was inserted by the Amendment Act of 1983. Sometimes they ask this as well. Next 35. Which one of the following is correct? Theft can never be robbery. Wrong. Extortion can never be robbery. No. In robbery there is either theft or extortion. Yes. 3 is the answer. It is mentioned in the definition of robbery itself. Section 390 IPC. Now everything is about to change. The new IPC, CRPC and all that. Next 36. Which of the following is not true? An accused is not a child if at the time of commission of the offence the age of child is not below 16 years. It must be not below 18 years. Because definition of child mentioned in section 212 of Juvenile Justice Act provides that child a person who has not completed age of 18 years. So this is not true. If a child is above 16 years but under 18 years of age, an inquiry can be held into heinous nature of the offence. It is correct. It is mentioned in section 15 of Dhjs Act. The inquiry is to be conducted for a preliminary assessment with regard to mental and physical capacity to commit such an offence. Also mentioned in section 15. After such inquiry, board can transfer the case to Children's Court for trial. It is also correct. It is mentioned in section 15, subsection 2. So 1 is not true, 1 is the answer. Next 37. The Juvenile Justice Care and Protection of Children Act provides for a juvenile justice fund to be credited for the welfare and rehabilitation of children. Yes, it is correct. Setting up of state child protection unit. Yes. Child welfare police officer, special juvenile police unit. Yes. All of the above. 4 is the answer. Next 38. A, being a teacher, calls his student after the class to the staff room and after shutting the room puts his penis into child's mouth. He commits aggravated penetrative sexual assault. 3 is the answer. Mentioned where? Section 5 of POCSO Act. Next 39. What is true of offence committed by a commercial organization under section 9 of Prevention of Corruption Act? It includes a body which is incorporated outside India and carries on a part of its business in India. It is correct. Company is liable to be punished with a fine if any person associated with it commits an offence under section 8 to obtain business from the company irrespective of whether such person is prosecuted thereunder. The director is liable to be proceeded against for an offence committed by a company only if it is proved that it was committed with the consent or connivance. All of the above. 4 is the answer. Next 40. Any person or organization which offers or receives a child for adoption without following the provision or procedure for adoption as provided under Juvenile Justice Act and rules thereunder would open itself to punishment under section 80. कितनी punishment है? Imprisonment which may extend to 3 years or fine of rupees 1 lakh or both. 1 is the answer. Next is 41. Which of the following is not relevant criteria as specified in Trademark Act for declaring a trademark as well-known trademark within the meaning of section 21ZG of the Trademarks Act? So, extent to which the trademark has been industrially applied in the class in respect of which it is registered. So, it is not mentioned. So, recognition of the trademark in the relevant section of the public. Yes, it is correct. Geographical area of promotion of the trademark. It is correct. Extent to which intellectual property rights based on the mark has been successfully enforced. So, what is not correct? Not a relevant criteria. Extent to the trademark has been industrially applied. So, 1 is the answer. Next, 42. Legislative provisions deeming registration to be prima facie evidence of validity are to be found in the Trademarks Act alone. 2 is the answer. And it is provided in section 137 of Trademarks Act. Next, 43. Fill in the blanks. Continuous non-user under section 47(1)(b) of Trademarks Act can be ground to seek cancellation of a trademark where the mark has been continuous disuse for 5 years from the date of registration up to a date 3 months prior to the date of application seeking cancellation. 3 is the answer. Next, 44. If assignment of copyright is executed in writing by the owner and author of the work but period of assignment is not mentioned in the deed, then what is the legal effect? It is not a valid assignment. It is still a valid assignment. Deemed to perpetual assignment? No. Assignment is considered to be valid for the entire term of copyright? No. It is considered to be assignment limited to a period of 5 years from the date of assignment. 4 is the answer. And it is mentioned in section 19 subsection 5 of Copyright Act. Next, 45. Can an unregistered trademark be assigned? Yes. Can be assigned with or without the goodwill of the business? 2 is the answer. And assignment of copyright is provided where? Section 18 of Copyright Act. Next, 46. A enters into contract with B to manufacture brake pedals exclusively for B. A, during the subsistence of the agreement, start manufacturing brake pedals for C. B files a suit seeking injunction against B manufacturing brake pedals for C. The contract of exclusive manufacture is void in terms of section 27. No. Unlawful? No. Voidable at the option of nay? No. It is valid and unforeseeable. 4 is the answer. Next, 47. A agrees to sell his house to B for a consideration of rupees 1 crore. On the date of transaction, the market value of the house was rupees 5 crore. The contract is void as it is without adequate consideration. No. It is valid and binding. 3 is the answer. Next, 48. Which of the following is not correct about minor in relation to partnership firm? He cannot become a partner. Yes, it is correct. He can be admitted to the benefit of the partnership. Yes. He is personally liable for the acts of the firm. No. He can elect to become or not to become partner within 6 months upon attaining majority. It is correct. So 3 is the answer. 3 is not correct. It is section 30 of Partnership Act. Next, 49. A contract to supply B, an Iranian company, 10,000 metric ton of rice by 1/4/2021. The agreement provides that in case the government of India prohibits export of rice, the contract shall stand terminated with respect to the unshipped quantity as on the date of prohibition order. A supplies 5,000 metric ton of rice by 1/4/2021. A and B executed an addendum to the contract extending the time of supply of the balance rice. The time of supply of balance rice on the same terms and conditions by 31/12/2021. Before any further supply takes place, the government of India bans export of rice wide order dated itna so and so. B files a suit against A seeking specific performance of the contract. So till that date, only 5,000 metric ton of rice has been exported, and this was only addendum for extension of the period, and the termination clause is still valid. So B is entitled for a degree of specific performance? No. Only degree of damages? No. Entitled to a degree of specific performance? No. Not entitled to any relief against A. 4 is the answer. Next 50, A and B enters into an agreement providing that in case of a dispute in relation to the agreement, the same shall be referred to arbitration under the aegis of the Singapore International Arbitration Center and seat of arbitration shall be at Singapore. Later, A filed a suit seeking declaration that arbitration clause was illegal. The arbitration agreement is void in terms of 28 Contract Act, F unlawful in terms of 23 F illegal void. Not illegal but is voidable at the option of A. It is not illegal or void, so 3 is the answer. They can refer to arbitration and they can choose their seat of arbitration. It is valid. Next 51. A will shall not be used as evidence until one attesting witness can at least be called for the purpose of proving its execution, if there be any attesting witness alive and capable of giving evidence. It is correct. It is mentioned in section 68 of Evidence Act. Until propounded thereof has proved the same, no. Until all attesting witness, no. Until registered, no. So 1 is the answer. Next 52. A pleads destruction of the original of a document relied upon. Along with the plaintiff files true photocopy of the said document. The defendant disputes the document. The plaintiff, to prove the document of secondary evidence, is required to file an application to the court for permission to lead secondary evidence. या फिर without filing application, prove destruction of the original. Yes, first thing he shall do this. Without filing any application for permission to lead secondary evidence, prove the copy to be true copy of the original. Yes. First do these things in 2 and 3, both 4 is the answer. Provision of secondary evidence is mentioned where? Section 63 and 65. Next 53. Whoever contravenes any rule or regulation made under IT Act for the contravention of which no penalty has been separately provided shall be liable to pay rupees 25,000. B is the answer. It is provided in section 45 of IT Act, residuary penalty. Next 54. A suit is filed by Mr. A for recovery of 5 lakh against Mr. B. A relies upon a letter dated so and so issued by B in his handwriting admitting that an amount of rupees 5 lakh is due and payable. Mr. B denies the letter has been written in his handwriting. Now A will have to lead evidence of the person acquainted with the handwriting of B or lead evidence of an expert to prove that said letter is in handwriting of B. It is correct. Mr. A will not be allowed to rely on this letter. No. Mr. A will have to file a criminal complaint. No. The said letter can be relied upon Mr. A in his examination as without seeking any independent evidence. No. So 1 is the answer. This is section 67 of Evidence Act. Next 55. Mr. X, who was unmarried, was employed overseas. He executed a will dated 1/10/2005 with respect to his properties and bequeathed the same to his sister Miss Y. Mr. X got married to Miss A on 1/10/2010 and unfortunately passed away in an accident on 1/12/15. The will dated 1/10/2005 is valid and will bind his estate. Or the will dated 1/10/2005 stood revoked by his marriage to Miss A as on 1/10/2010. Or is valid? No. Is valid? No. Stood revoked. 2 is the answer as per section 69 of Indian Succession Act. At the time of marriage, any will made by any unmarried person will become void. Next 56. A will may be revoked by another will or codicil. It is correct. In some writing declaration intention to revoke the same executed in the manner in which the unprivileged will is executed. Yes. By burning, tearing, destroying the will. Yes. 4 is the answer, all of the above. This is section 70 of Indian Succession Act. Next 57. When a borrower prefers an appeal before debt recovery appellate tribunal, the appellate tribunal has the absolute discretion to waive off the pre-deposit of due amount or has limited discretion to direct a pre-deposit amount of 50% to 25% of amount of debt due, which is inclusive of interest. So 2 is the answer. And where is the provision? In section 21 of Debt Recovery Act. Next 58. A Hindu male dies intestate. The property shall devolve on class 1 heir as per the schedule 1 under the Hindu Succession Act. Who is not a class 1 heir? Father is not a class 1 heir. Very common question. 1 is the answer. Next 59. Mr. A died on a 1/10/2010 in Mumbai while he was on vacation, leaving behind a registered will dated 25/12/2005. He had a fixed place of abode in Delhi and he left behind properties in Delhi which has value in excess of 10 crore. The petition of probate can be filed either before High Court at Delhi or concerned district judge at Delhi within whose jurisdiction the testator had fixed the place of abode, since the said court have concurrent jurisdiction. 4 is the answer. Next is 60. Which of the following is not a public servant under section 2C of the Prevention of Corruption Act? A court appointed liquidator. He is official bearer or office bearer of a residential welfare association. No, it is not. Arbitrator appointed by public authority. Yes. So 2 is the answer. Next 61. X and Y were officials posted in Department of Agriculture during year 21-22. In 23, on complaint of private citizen, it is revealed that there was department-wide corruption during COVID pandemic in year 2021. X has since retired and Y is now posted in Department of Health. What is the previous sanction required under section 19 of Prevention of Corruption Act for taking cognizance of offence punishable by X and Y? Sanction is required to prosecute X and Y both. So 3 is the answer. Next 62. X is tried for the offence of criminal breach of trust in relation to company property which it is alleged was entrusted to him for company use. Several subordinates of X appears as defense witnesses at a trial and depose that X was a person of high integrity and character and would never be so petty as to misuse company property for personal use. Which of the following statements is accurate? Being a criminal case, previous good character of X is wholly irrelevant. No, it is relevant always. Being a criminal case, X is entitled to acquittal solely based on the proof of his previous character. No, it is wrong. Before character evidence given by witnesses is accepted, the character of the witnesses themselves must be proved. No, it is not required. Being a criminal case, character evidence is very weak evidence and cannot outweigh positive evidence against X which proves his guilt. It is correct. 4 is the answer. Character evidence is a weak type of evidence. Where are the provisions? Section 53 to 55 of Evidence Act. Next 63. Which of the following statement is true regarding procedure to be followed by a special judge in conducting trial under Section 6 of Prevention of Corruption Act 1988? May take cognizance without accused being committed to him for trial. It is correct. Shall follow the procedure prescribed trial of warrant case. Yes, it is correct. Shall exercise all the powers exercised by a district judge under the Criminal Law Amendment Ordinance 1944. Yes, it is correct. All of the above 4 is the answer. And these are mentioned where? In section 5. Section 6 is power to try summarily. And for exercising that power, he requires the power of section 5 in Prevention of Corruption Act. Next 64. At which stage is the offence of attempt to murder under section 307 committed? A. Intending to murder Z by poison, purchases poison and mixes the same with the food which remains in A's keeping. No, preparation is incomplete. A. Places the food on Z's table or deliver it to Z's servant to place it on Z's table. Only after completion of stage 2. Stage 1 is incomplete. So both is required to be done only after stage 2. So 2 is the answer. Next 65. Which of the following is not correctly matched? Sedition 124A correct. 361 kidnapping from lawful guardian. Yes. 304B dowry death. Yes. 357 assault of criminal force to woman with intent to outrage her modesty. That is 354, not 357. So 4 is the answer, not correctly matched. 357 is assault of criminal force with intent to confine a person. Next 66. Section 53 IPC does not envisage is capital punishment. Yes. Hard labor. Yes. Solitary confinement. No. It is in section 73. So 3 is the answer. Next 67. A and Z are friends. A goes to Z's house and in Z's absence takes away a book without Z's consent. A was under the impression that he had Z's implied consent to take the book for purpose of reading it. Now A sells the book to B for his own benefit. A is guilty of dishonest misappropriation of property. 2 is the answer. How? Till here, where he has implied consent, it is no theft. But now, when he has the book and sells it, it is misappropriation of that book. It cannot be criminal breach of trust because there is no entrustment by Z to A. Next 68. A is found in possession of counterfeit notes, knowing the same to be counterfeit and intending to use the same as genuine. A is liable to be punished under with section 489C. 3 is the answer. Next 69. A causes Z to go within a walled space and locks Z in. A is thus prevented from proceeding in any direction beyond the circumscribing line of a wall. A has committed an offence under section 340, wrongful confinement. 2 is the answer. And 339 is wrongful restraint. 350 is criminal force. And 348 is wrongful confinement to extort confession or compel restoration of property. So 2 is the answer. Next 70. A finds a valuable ring on road, not knowing to whom the ring belongs. Without attempting to discover the owner, A sells the ring immediately. A has committed the offence of criminal misappropriation, dishonest misappropriation under section 403 IPC. 2 is the answer, and this is illustration in that section. Next 71. A transfer of immovable property made with the intent to defeat or delay the creditors of the transferor. It is void ab initio or voidable at the option of any creditor so defeat or delayed. 2 is the answer. This is fraudulent transfer mentioned in section 53 of Transfer of Property Act. Next 72. A lease of immovable property in Delhi for commercial purpose in the absence of contract to contrary is terminable on the part either of lessor or lessee by 15 days notice. 1 is the answer. It is mentioned here 106. How? See, it is mentioned that lease of immovable property for agriculture or manufacturing purpose, then it is year to year and terminable by 6 months notice. And any other lease is month to month and terminable by 15-day notice. So 1 is the answer. Next 73. Shamlal, in consideration of monies borrowed from Ramlal, under cover of his letter, delivers to Ramlal document of the title of his immovable property in Delhi with intent to create a security thereon. Neither is the said letter stamped as mortgage, nor it is registered. On Shamlal not repaying the monies, Ramlal, after nearly 8 years of the date when the loan was made to Shamlal, institutes a suit to enforce payment of money secured by mortgage. Shamlal takes a plea that suit is time barred and should have been filed within 3 years from the date when loan was made. The said suit is barred by time or within time. Is it within time? Because it is mortgage by deposit of title deed. The time period limitation is 12 years as per Article 62 of Schedule of Limitation Act. So it is within time. 2 is the answer. Next 74. A sale of immovable property during the pendency of a suit in which any right to such immovable property is directly or specifically in question is barred by law या फिर is void between the seller and the buyer, is binding on all the parties if it does not affect the right of any other party to a suit under any decree or order which may be made therein. 4 is the answer. Doctrine of lis pendens will be applicable as per section 52 Transfer of Property Act. Next 75. Ramlal is a famous painter. He paints a portrait in 1944. The portrait remains in his possession and is first exhibited only in 1950. Ramlal dies on 29 February 1960. Till when will copyright in the portrait subsist? For 60 years from its first exhibition, from date of death of Ramlal. 60 years from the beginning of calendar year following the year in which author died. So starting from 1st January 1960, 60 year will end on 31st December 2020. 4 is the answer. This is mentioned where in section 22 of Copyright Act. Next 76. A owns a patent registered in Mumbai. B, who is from Hyderabad, filed an application for grant of patent at Chennai. When published, A files an opposition under Section 25(1) of the Act opposing grant of B's patent. A also filed suit for infringement of patent in Delhi High Court invoking territorial jurisdiction on the basis of availability of product of B in Delhi. The opposition of A was allowed by the controller of patent at Chennai. B wishes to challenge the order by filing an appeal. Which High Court would have jurisdiction to entertain the appeal? So B is filing an appeal on the order of allowing the opposition of A. Therefore, Chennai High Court means Madras High Court will have the jurisdiction. High Court of Madras. 3 is the answer. Next 77. Of the following, which is never patentable as an invention? A mathematical or business method, it cannot be patented. A mere new form of a known substance, it can be. A computer program per se. An invention which is traditional knowledge, no. So A, C, D cannot be patentable as an invention. It can be patented as a discovery. So 3 is the answer. And where this is mentioned, it is mentioned in section 3 of Patent Act. What are not inventions? And section 25 says what is not invention, it cannot be patented. Next 78. In a civil suit filed by an licensee from infringement of a copyright, is it necessary that owner of work is to be party? Owner is a necessary party unless court directs otherwise. Obviously 2 is the answer. Next 79. What act does not amount to infringement of copyright? Importation of work into India, it is infringement. Doing anything which is in exclusive domain of the owner, it is infringement. Display of work by way of trade, it is infringement. Fair dealing with any work, it is not. 4 is the answer. Next is 80. Where the challenge to arbitrator is not successful, the arbitral tribunal shall stay the proceedings, giving opportunity to the party to take recourse to appropriate legal proceeding against the order. No. फिर arbitral tribunal shall continue the arbitral proceeding but not make an arbitral award till the disposal of the proceedings if any initiated by the party challenging the arbitration against the said order. या फिर arbitral tribunal shall continue the arbitral proceeding and make the award. Will continue and make the award, obviously, only with the consent of the party. No. So 3 is the answer. And where this is mentioned, it is mentioned in section 13 subsection 4 of Arbitration Act. Next 81. The entry measure by the court can be ordered on an application by a party during the arbitral proceedings at any time before enforcement of the award before arbitral proceedings. All of the above. 4 is the answer. This is section 9 of Arbitration Act. Next 82. Consider the following statements with respect to the 4th schedule of Arbitration Conciliation Act as applied to 3-member arbitral tribunal. The highest fee is payable per arbitrator under Arbitration Conciliation Act is of rupees 30 lakh. Yes, it is correct. The ceiling limit of 30 lakh is inclusive of both the base amount and variable amount of fees. This is also correct. The ceiling limit of 30 lakh in terms of arbitral fee is applicable for each arbitrator individually and not the arbitral tribunal as a whole. This is also correct. This has been recently held in a case ONGC versus Afcon Gunanusa JV joint venture, held in year 2022. Next is the ceiling limit of 30 lakh does not apply to fixed component but applies only to the variable component. No, it is wrong. So 1, 2 and 3 are correct. 4 is the answer. Next 83. An oral arbitration agreement may be recognized at the discretion of the arbitrators. या फिर is not recognized या फिर maybe. It is not recognized as arbitration agreement. 2 is the answer. Because arbitration agreement must be in writing. It is mentioned in section 7 subsection 3 of Arbitration Act. Next is 84. How many gold medals has India won in total in the history of Olympic Games? So total 10 medals. 2 is the answer. Next 85. The Hindi movie Omkara by Vishal Bhardwaj is an adaptation of which one of the following Shakespearean plays? It was based on Othello. But what is the point of asking that old movie and now here? One is the answer. Next 86. The Torres del Paine National Park is situated in Chile. One is the answer. So you can see this is the Torres del Paine National Park. These are the pictures of their surroundings. And this is situated here. You can see this. Parc Nacional Torres del Paine. Next 87. Who is the director of American fantasy movie Barbie, which was recently released in July 2023? It is Greta Gerwig. This movie was in a big controversy as well. 4 is the answer. Next 88. On which date did Russia invade Ukraine in the ongoing Russia-Ukraine war? On 24th February 2022. 3 is the answer. Next 89. Which amongst the following states the correct type of B vitamins? So B1, B2, B3, 5, 6, 7, 9 and 12. 1 is the answer. Next 90. The blanks in the following sentence can be filled in the correct order as the cattle are grazing. Because cattle is not a singular, it is a plural word. Village folk. Folk is also plural word. So are up early in the morning. Every boy and girl. So this is singular. Is given a prize. So 3 is the answer. Next 91. Which player has won Women's Single Wimbledon Lawn Tennis Title of the Year 2023? It was Marketa Vondrasova. 2 is the answer. Next 92. Which word from amongst the following describes a man who loves to travel? Hodophile. 1 is the answer. Opocarophile, who loves sunsets. Fond of viewing the sunsets. Melanophile, who loves black color. Raconteur, who is the contour? Who tells short stories in a amusing way. So 1 is the answer. Next 93. Which provision of the Minimum Wages Act covers payment by an employer for overtime by an employee? It is section 14. 4 is the answer. Next 94. What is the maximum wage period for payment of wages? It is 1 month. 1 is the answer. Next 95. Which kind of dispute of an individual workman is deemed to be an industrial dispute where no other workman nor any union are party to the dispute? Suspension of individual workman, no. Dispute regarding work condition of individual workman, no. Seniority, no. Discharge, dismissal, retrenchment or otherwise termination of service of individual workman. 4 is the answer. It is mentioned in section 2A of Industrial Dispute Act. Next 96. Within how many days a notice has to be given to workmen by the employer in case of any changes proposed to be effected in respect of a matter specified in Schedule 4 of Industrial Dispute Act? It is 21 days. 2 is the answer. It is mentioned in section 9A of Industrial Dispute Act. Next 97. Under which provision of Industrial Dispute Act can a workman claim full wages last drawn by him during pendency proceedings in higher court? Under section 17B. 2 is the answer. Next 98. What does second schedule of Industrial Tribal Act deals with? Industries which may be declared to be public utility service matter within the jurisdiction of Industrial Tribunal or labor courts. It is about the labor courts. 3 is the answer. Industrial Tribunal, this is Schedule 3. Unfair labor practices, it is Schedule 5. And this public utility service, this is Schedule 1. Next 99. Adolescent under Minimum Wages Act means who has completed age of 14 years but not completed age of 18 years. 4 is the answer. And definition is provided in section 2A of Minimum Wages Act. Next 100. A is undergoing a sentence of imprisonment for life and is sentenced in a subsequent conviction for a term of imprisonment for life. The subsequent sentence will commence on expiration, या फिर the court can direct that subsequent sentence shall run concurrently. The subsequent sentence shall run concurrently with the previous sentence. 3 is the answer. It is mentioned in section 427 CRPC. Next 101. A is charged by magistrate of second class with and convicted by him of theft of property from a person of B. A can be charged with and tried for theft on the same facts. No. Tried for robbery on the same facts. Yes. Tried for theft. No. So 2 is the answer. And this is illustration E in section 300. Next 102. Which of the following is true of a statement of a witness recorded under section 161 CRPC? Section 161 CRPC statement can be used only to contradict a witness's court testimony. Yes, it is correct. Can used to contradict or corroborate? No. Statement is useless in court? No. Can be used by investigating officer? No. So 1 is the answer. It is mentioned in section 162 CRPC. Next 103. An offence, though compoundable with the leave of the court, cannot be compounded under section 320 if the person who would be competent to compound is dead. It is correct. Otherwise be competent to compound is under the age of 18 year or idiot lunatic. Yes, it is correct. If the accused by previous conviction liable to enhanced punishment. Yes. All of the above. 4 is the answer. It is mentioned in section 320 subsection 4. Next 104. In the course of investigation, the investigating officer induces an employee to steal documents from the office of the accused. The stolen documents are sought to be adduced in evidence in the course of trial. Which of the following does the law mandates? The court must refuse to admit the documents in evidence since these were stolen from the office of the accused. No. The court must first decide provenance of the document. No. Admissible in evidence regardless how they are obtained. The court must direct registration of FIR alleging the offence of theft against the employee and with the investigating officer as co-accused. The documents are admissible in evidence regardless how they were obtained. It is totally correct. The court must direct the registration of FIR alleging offence of theft against the employee and with IO of as co-accused. 3 is the answer. Next 105. An accused in police custody makes a self-incriminating statement. Article 23 of Constitution grants to an accused the right against self-incrimination. Therefore, such statement made by an accused can never be used against him in the course of trial unless such statement made in presence of some prosecution witness या फिर defense witness या फिर was read with Miranda warnings as prescribed in Miranda versus Arizona as accepted by Indian Supreme Court, or such statement contains information that relates distinctly to the discovery of relevant fact. 4 is the answer as per section 27 of Evidence Act. Next 106. While being examined in court, a prosecution witness makes a statement which belies the prosecution case. What is the meaning of belly? Belly means fail to give true impression. Means not corroborated to the prosecution case. The prosecutor declared the witness hostile and opts to cross-examine him. Which of the following is true? The entire testimony of such witness must be discarded by the court since the prosecution witness was not supported in the case of the prosecution. No. The court must itself ask the witness as to why he has not supported. No. The matter must be urgent for the prosecutor to bring the witness and bring him back for his examination in chief on subsequent date. No. The entire testimony of the witness need not to be discarded and the court is entitled to rely upon those part of testimony as it find admissible, credible and trustworthy, whether it be consistent with the case of the prosecution or the defense. It is correct. 4 is the answer. This section talks about hostile witness, section 154 Evidence Act. Next 107. Which one is not correct? Media personnels are obliged to provide all information to special juvenile police unit or local police if they come across any material object which is sexually exploitative of a child. It is correct. It is mentioned in section 20 of POCSO Act. Next, a doctor can take a call to report a case to the police where doctor conducts a medical termination of pregnancy of a minor girl who has been involved in consensual sexual intercourse resulting in pregnancy. It is also correct. For any person being in charge of an institution who fails to report commission of an offence under the act by his subordinate is liable to be punished with imprisonment for a minimum period of 1 year under section 21. This is wrong. How? It is mentioned minimum period. It may extend to 1 year. So this is wrong. Any person other than child who makes false complaint about the commission of an offence under the act also commits an offence can be subject to punishment up to 6 months imprisonment or fine or both. It is correct. It is mentioned in section 22. So 3 is wrong. 3 is the answer. Next, 108. Which of the following is incorrect? When there are no funds in the account and stop payment instructions have been issued, a complaint for dishonor of check can be filed. Yes, it is correct. The bank's slip or memo bearing the official mark denoting dishonor of a check will be prima facie evidence of the fact of such dishonor. Yes, it is correct. It shall be presumed, unless proved contrary, that the holder of the check received the check for discharge of legal enforceable debt or liability. It is correct. It is valid defense against the prosecution that drawer had no reason to believe at the time of issuing a check that it would be dishonored or presentment. No, it is no presumption, no defense. So 4 is the answer. It is incorrect. Next, 109. A is 17-year-old and is a student of class 11. He is attracted to B, who is a fellow student. He follows her activity by constantly watching her in class and smiles at her with sexual intent. A has committed the offence of sexual harassment. 2 is the answer. Sexual harassment is mentioned in section 11. Sexual assault in section 7 of POCSO Act. Next, 110. Which is not correct? Death is the highest punishment provided for an offence under POCSO Act. It is correct. Minimum punishment for aggravated penetrative sexual assault is 20 years rigorous imprisonment. It is correct. The maximum punishment for penetrative sexual assault is life imprisonment. It is correct. Sentence of fine only can be avoided to a person found guilty of sexual harassment. No. It is mentioned in section 8 and 3-year imprisonment is there. So 4 is wrong. 4 is the answer. Next, 111. The maximum permissible time within which written statement can be filed in a commercial suit from the date of service of summons is 120 days. 1 is the answer. It is mentioned in Order 8, Rule 1, Proviso. Next, 112. The plaintiff as owner instituted a suit for declaration as null and void of a sale deed of immovable property in favor of defendant and for cancellation of the said sale deed, and for the relief of permanent injunction to restrain the defendant from dispossessing the plaintiff from the property. The suit for the relief of declaration of sale deed as null and void and for cancellation thereof is dismissed on merits. The court is entitled to decree or is not entitled to grant relief for permanent injunction because no injunction against true owner of title holder and in favor of person in unlawful possession can be granted. 3 is the answer. Next, 113. Plaintiff institutes a suit for specific performance of an agreement for sale of immovable property and in the alternative of recovery of damages in the sum of 2.5 crores. The plaintiff, after more than 3 years of institution of the suit, but before commencement of the trial, applies for the amendment of the plaint to enhance the claim for damages to that of rupees 5 crore. The application for the amendment is barred by Order 2, Rule 2 or constructive res judicata. No. Neither barred by Order 2, Rule 2 nor by constructive res judicata. 3 is the answer. Can be given. Amendment of plaint is provided where? Order 6, Rule 17. Next, 114. As per section 101, second appeal lies to High Court on substantial question of law. 1 is the answer. Very common question. Next, 115. Where would a suit for compensation for wrong to a person be instituted if wrong is committed within the territorial jurisdiction of one court and defendant resides within the territorial jurisdiction of another court? Either of 2 places. 3 is the answer. And this is section 19 CPC. Next 116, a contract the performance of which involves the performance of a continuous duty cannot be specifically enforced, never specifically enforced, ever is not specifically enforced only if the court cannot provide such performance. 2 is the answer. It is mentioned in section 14 and clause B. Next 117, which of the following is not correct? The plaintiff in a suit filed seeking perpetual injunction can also claim damages in addition. Yes, it is correct. Filed seeking mandatory injunction can in substitution for such relief seek damages. Yes. Plaintiff files a suit for perpetual injunction. The court may, without a prayer of plaintiff, instead grant damages. No, only if it is prayed. So 3 is not correct. 3 is the answer. So perpetual injunction when granted under section 38, mandatory injunction 39 of Specific Relief Act. And it is mentioned in section 40 that no relief for damages shall be granted unless plaintiff claimed for such relief in his plaint. Next 118, which of the following is correct? A decree of declaration is binding on the party to the suit. It is correct. Is binding in rem? No, it is in personam. So binding to all those who claims property with subject matter of the suit, is not binding upon person claiming through other parties. Is binding on the party to the suit only. 1 is the answer. Next 119, whether registration is necessary in order to protect rights by the owner of the design under Design Act. So registration is not necessary, या फिर common law remedy substitution addition to registration, या फिर yes, registration is prerequisite before any action for protection. 3 is the answer. Next is 120. In which field of intellectual property is judgment in Bharat Glass Tube versus Gopal Glass Works an authoritative pronouncement? In Design Act. 2 is the answer. Next 121. Which of the following is not correct? Regarding section 6 of Specific Relief Act, the period of limitation for filing a suit thereunder is 6 months. It is correct. No suit against government can be brought under the said section. It is correct. Order or decree passed under the section is immune from challenge by appeal or as well as review. It is also correct. It would be necessary for the plaintiff to prove absolute title. No, it is not. 4 is the answer. Only possession is required to be proved. Next 122. The plaintiff files a suit after expiry of the prescribed limitation period. As he was seriously unwell, he filed a suit on recovering along with an application under section 5 of the Limitation Act. Now, just note this, it is a suit and application filed under section 5. Pleading that there shall be sufficient cause for not filing suit within time. Would the court condone such delay? The plaintiff has shown sufficient cause. Delay would be condoned. No. Satisfied about the bona fide contention. No. The suit would be dismissed being time barred. 3 is the answer. Why? Because the application is wrongly filed. If he want to take the condonation of delay, he should have filed application under section 3 of Limitation Act read with order 7 rule 6 of CPC. Condonation for delay for filing suit. Notice section 5. 5 is only for appeals and applications. Next 123. Where part payment on account of a debt is made before the expiration of prescribed period of limitation, what is the effect of the same on the prescribed limitation period? It has no effect. A fresh period of limitation shall be computed from a time of payment. 2 is the answer. This is section 19 of Limitation Act. Next 124. A sale of immovable property by execution of sale deed without paying the entire sale consideration is void, voidable, void, or valid. Is valid, but the seller has charged upon the property in the hands of the buyer for amount of the purchase money remaining unpaid and for the interest on such amount from the date of which possession has been delivered. 4 is the answer. Next 125. A newspaper publishes an article defaming the plaintiff. The limitation period to sue for compensation would be 1 year from when the article was published, या फिर 3 years, 2 years, 6 years. 1 year. 1 is the answer. It is provided in Article 75 of Schedule of Limitation Act. Next 126. Pursuant to a loan given by a plaintiff, the defendant defaulted. The prescribed limitation period to file a suit expired. However, the defendant thereafter in writing acknowledged the debt Which of the following statement is correct? So the prescribed limitation period has been expired and defendant after the expiry of that period gave an acknowledgement. So in the case plaintiff files a suit for recovery, the suit would be time barred. Yes, it is correct. The limitation of filing of suit by the plaintiff is extended from the date of said written acknowledgement. No, it should be within the prescribed period. It is mentioned in Section 18 Limitation Act. The plaintiff can now file a suit for recovery in case a default continues but cannot claim penalty interest. No, he can also claim penalty interest. He can file suit for recovery in case, how? Because as per Section 25 exception 3 in Contract Act, it promised to pay time bar debt becomes a agreement and enforceable in law. So he can also enforce on that promise. Right, so it become a separate contract. In this question, 1 is the answer. Next, 127. In case of warranty, the buyer can repudiate the contract if it claim damages only. Claim damages only. Cannot repudiate. 2 is the answer. And where this is mentioned, it is mentioned in Section 12 of Sale of Goods Act. Next, 128. Consider the following statements. While deciding a petition under Section 9 of Arbitration Conciliation Act, the court can completely ignore the basic principle of CPC. No. Is strictly bound by rigors of every procedural provision. No. Has to see whether applicant has good prima facie case and the balance of convenience in the favor of the interim relief. Yeah, it is correct. Power is wider than the power given to a court under the provision of CPC. It is correct. So 3 and 4 are correct. 3 is the answer. Next, 129. Which of the following statements is incorrect? The goods which form the subject matter of a contract of sale may either be existing goods owned or possessed by seller or future goods. It is correct. This is Section 6 of Sale of Goods Act. Next, there may be contract for sale of goods acquisition of which the seller depends on the contingency which may or may not happen. It is also correct. The contract for sale of goods not owned or possessed by seller is void. No, it is still valid because contract for sale of future goods as well. So this is wrong, incorrect. Contract to effect a present sale of future goods operates as an agreement to sell the good. It is correct. So 3 is the answer. Next, 130. Which of the following statement is correct? Where there is an agreement to sell goods on the term that the price to be fixed by the valuation of a third party and such third party does not make such valuation, the agreement is avoided. This is correct. The price in a contract for sale of goods may be fixed by the contract and may be left to be fixed in a manner thereby agreed or may be determined by the course of dealing between the parties. This is also correct. This is Section 10. This is Section 9 of Sale of Goods Act. Where the price is not determined in accordance with the modalities agreed by the parties for determination thereof, the buyer is required to pay the seller reasonable price of the goods. This is also correct. So all are correct. 4 is the answer. This is Section 9 itself and subsection 2 in Sale of Goods Act. Next, 131. Mr. X died intestate on 30/4/1990, leaving behind his self-acquired immovable property. The said property was inherited by his sole legal heir, his son Mr. Y. The said property becomes self-acquired property of Mr. Y. His children will not get any right by birth in the said property. It is correct. The said property become ancestral property in hands of Mr. Y. No. Will it inherit 50%, 75%? No. So 1 is the answer. Next, 132. Mr. D died intestate on 1/10/2000, leaving behind a residential house which is admittedly a co-partnership property. He was survived by a son and a daughter. Dispute arise between the parties leading to a civil suit for partition being filed by the daughter on 1/10/2006. Both son and daughter will succeed to the co-partnership property in equal share. Obviously, it is correct. Son will succeed. Sole owner no. Daughter no. The son had a pre-existing right of 50% of share as its co-partner. Daughter only had 50% of the property, and this 50 share will be inherited by son. No, it is wrong. So 1 is the answer. 50-50 milega. Daughter is also co-partner by birth. Next, 133. Mr. X died intestate on 1/10/2012, leaving behind a dwelling house wholly occupied by members of his family. He was survived by his widow, two married sons, one unmarried daughter, and one married daughter. So let's make it over here. This is Mr. X died. He has widow, two sons S1, S2. They are married, and one daughter married, and one another daughter unmarried. So two daughters, two sons. His married daughter filed a suit for partition of the dwelling house, claiming 1/5 share in the said house. Yeah, she can claim. Civil suit partition is not maintainable until two married sons or choose to divide. No, it is wrong. Not maintainable until widow. No. Civil suit of partition filed by married daughter is maintainable. Yeah, it is correct. 3 is the answer. Next one, 34. A father F dies in 2001 and is survived by one son, two daughters, and a wife. The grandson files for partition of immovable property of F against the son without impleading the two daughters of F. The suit for partition is, no, it is liable to be dismissed for non-joinder of two daughters, या फिर liable to be rejected as plaintiff has no locus standi to file the suit. No locus standi. 2 is the answer, because partition would be happening only between the sons and daughters and widow. 2 is the answer. Next one, 35. An order allowing an application under section 8 of Arbitration Conciliation Act is appealable or is not appealable? Is not appealable under section 13 of Commercial Courts Act. 1 is the answer. Next one, 36. A raises a claim of rupees 5 crore in arbitration. B raises a counterclaim of rupees 2 crore in the said arbitration. The final award of 4 crore is passed in favor of A. Specified value for determining the jurisdiction of the court shall be 7 crores. 2 is the answer. So specified value is mentioned where? In section 2I of Commercial Courts Act, and will be determined as per the section 12 of Commercial Courts Act. Next one, 37. In a claim for compensation in a case of death due to an accident arising out of use of motor vehicle, compensation cannot be granted unless the claimant show that the motor vehicle being driven in a rash or negligent manner. No, it is wrong. Compensation can be granted even where the claimant is unable to establish that death was due to any wrongful act, neglect, or default in driver owner of the motor vehicle. 2 is the answer. This is section 140 of Motor Vehicle Act. Next one, 38. A files a suit for recovery of money lent to B. B files a counterclaim in the suit. For purposes of determining specified value of commercial dispute, which of the following is to be taken into account? The money sought to be recovered up to date of the filing of the suit. 3 is the answer. About specified value, it is mentioned in section 12 of Commercial Courts Act. Next one, 39. Under order 13A of CPC, as applicable to commercial disputes, court can give a judgment only in favor of plaintiff defendant, या फिर in favor of plaintiff or defendant, as the case may be. Obviously 4 is the answer. Next, 140. Provision of IT Act apply to offences committed by a person outside India if offence involves computer or computer network located in India. 2 is the answer. It is mentioned in section 75 of IT Act. Next, 141. A holds a lease from B terminable on 3-month notice. C, without any authority from B, gives a notice of termination to A. Such notice is valid or invalid. It is not binding on A as B cannot ratify the same. So 4 is the answer. Next, 142. A obtains a contract from the government to provide security service in one of the offices. Later, it is discovered that A had given a bribe to one of the officers in the tender committee to obtain the contract. The government cancels the contract. Such cancellation of contract is invalid, or A can seek specific performance of the contract. A is not entitled to claim even for the security service provided by it to the government prior to the date of termination of contract. 3 is the answer, because it was obtained through illegal gratification. Next, 143. Which of the following is the appellate tribunal for the purpose of provision of IT Act? This Telecom Dispute Settlement and Appellate Tribunal. 1 is the answer. It is mentioned in section 48 of IT Act. Next 144. In an inquiry before motor accident claim tribunal, the claimant must prove their claim beyond reasonable doubt या फिर on preponderance of probability. On preponderance of probabilities. 2 is the answer. Next 145. ABC Insurance Company, on receiving a check for the issuance premium from H, issues an issuance cover for the vehicle owned by H. The check is returned dishonored for insufficiency of funds. The vehicle meets with accident. The insurance company is not liable. Will be liable to pay compensation amount unless the policy was cancelled by it and intimation of such cancellation has reached insured before the accident. 3 is the answer. Next 146. In a claim petition, the insurance company is able to prove that the vehicle which caused the accident was being driven by a person who was not holding a valid driving license. The insurance company shall be absolved of liability to pay compensation. No. The insurance company shall have to pay compensation to the claimants but will be granted a right to recover from the same from the owner of the vehicle. 2 is the answer. Next 147. A, who is the registered owner of the motor vehicle, transfer the same to B. However, he does not apply for transfer or registration in favor of B. The motor vehicle meets with an accident leading to death of a person. As A has already sold the vehicle, he shall not be liable. No, he will be liable. A shall remain liable to pay compensation as he remains the registered owner of the vehicle as on the date of the accident. 3 is the answer. Next 148. A files a suit. So this is, I think, wrongly mentioned. A files a commercial suit against B claiming recovery of 5 crore from B without instituting pre-institution mediation. There is no urgent relief sought in the suit. Which of the following statement is correct? The suit shall be rejected under Order 7, Rule 11. 1 is the answer. How? Order 7, Rule 11 mentions in Clause D that anything barred by law. Alright. And Section 12A of Commercial Courts Act mentions that if there is no urgent relief, then pre-institution mediation is compulsory. So therefore it shall be rejected. 1 is the answer. Next 149. The defendant, instead of filing his written statement to a commercial suit, filed an application under Order 7, Rule 11. The application was dismissed by the court. However, in the meantime, 150 days has passed since the service of summons of the suit on a defendant. Defendant prayed that he be granted 1 week to file written statement. The court shall grant him a time, or as it was a fault of the court application of defendant. No. The court cannot grant extension of the time of defendant to file written statement 120 days having passed on the service of summons on him. Well, it was his choice to file the Order 7 Rule 11 application. So 3 is the answer. And it is also mentioned in Order 8 Rule 1 Proviso, where the period for limitation, where the prescribed period of 120 days has been mentioned, that the court shall not allow written statement to be taken on record if not filed within 120 days. Next 150. Aggrieved of the judgment and decree passed in commercial suit, the defendant filed an appeal to the commercial division of the High Court. Which of the following is correct? The period of limitation of filing such appeal shall be governed by Article 116 and 117 of Limitation Act. No. It shall be governed by Section 13(1)(a) of Commercial Courts Act and Section 5 of Limitation Act shall also not apply. It is correct. So 2 is the answer. So friends, here we have discussed all the questions of recently held preliminary exam paper of Delhi Higher Judicial Services 2023. This was quite a tough paper, not an easy one, and very lengthy as well. अगर आपको इसमें कोई कमी लगी हो, कोई सजेशन हो, कोई एडवाइस हो, कोई कमेंट्स हो, तो आप जो है कमेंट सेक्शन में जाकर भी लिख सकते हैं. वी ऑलवेज अप्रिशिएट योर कमेंट्स. एंड अगर आपको ये वीडियो अच्छी लगी और एफर्ट्स हमारे अच्छे लगे हो तो इसको जरूर लाइक कीजिएगा, शेयर कीजिएगा अपने फ्रेंड्स के साथ, सो दैट दे कैन कम टू नो अबाउट आवर चैनल एंड वो भी बेनिफिट ले सकें. एंड अगर आपको हमारे एफर्ट्स अच्छे लगे हो तो इन एडिशन टू लाइक एंड सब्सक्राइब काइंडली गिव अस अ सुपर थैंक्स. सुपर थैंक्स इज अ वे टू अप्रिशिएट द कंटेंट क्रिएटर. आप जो है जो भी कंटेंट बनाता है उसको अप्रिशिएट करने के लिए कोई भी अमाउंट जो है डोनेट कर सकते हैं. फ्रॉम मिनिमम स्टार्ट्स विद 40 रुपीज़. तो काइंडली गिव अस अ सुपर थैंक्स. So friends, thanks very much for watching this video. Thank you.